Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull and Toronto, here are Ian and Susanna.
Hi, and welcome to Hull and Estates and Succession Planning.
Hi there, Ian.
Hello, Susanna.
How are you today?
I'm much better than you. I understand you've got a cough and a cold, and she threatened not to podcast today with me, but I insisted. So if she needs to have a break for some water, we're okay with that.
And this time I'll remember to take my mic off.
So today is a very exciting day. And for those of you who may not know this, we're actually podcasting today on February 21st. It's not quite 3 p.m. today, but at 3 p.m. today, Twitter will have hit 3 p.m. yesterday, Twitter has hit the 500 million mark. So, just so in case anybody was wondering if Twitter was here to stay, it's pretty well here to stay.
Well, that's pretty close to the number of tweets that you have out there on the internet, isn't it?
Yes. No, it's the number of followers I have.
Oh, yes, of course. That too.
And I. On that note, as we try to do from time to time, talk about books we're reading. This is a new book that, not all that new, but new to me, the 2012 edition of LinkedIn and Blogs for Lawyers. And it is written by Adrian Dayton and Amy Knapp. And Adrian and Amy are both well known on the Twitter sphere and the internet social media world. But this is a great, the 2012 edition is a phenomenal book. I've been working through it recently. It adds some basic level information for lawyers for Twitter and LinkedIn, which is an interesting sort of component to it. But it's a helpful book for both the beginners and the advanced. I was asked by my son this weekend, what exactly is LinkedIn? He's a teenager. And I said, LinkedIn is FaceTime for professionals.
You mean Facebook?
FaceTime. Good. That's Apple. Facebook for lawyers, not lawyers, for professionals. And he instantly got it. And sure enough, within about the first 20 pages of this book, that's how they define LinkedIn.
Well, I'm actually quite shocked how much LinkedIn has taken off and how rapidly it's been sort of embraced by professionals out there. I can't imagine your experience, but constantly I'm being invited to befriend someone on it, and it's a really hot medium right now. So I'm quite impressed with it myself, and I know many others are as well.
Well, again, you'd have a lot more offers to link in than I would because of your success in the social media world, but I get the odd one too, and it's a great program. But this is a really good book. It's an old-fashioned hard copy of the book, which gives me some good guidance on terms of the basics on LinkedIn. So we want to talk today about a topic that yesterday we spent the day, half a day, at the Law Society of Upper Canada speaking on, and we thought it would be kind of helpful to flesh out some of the core elements of it. The topic yesterday and some of the elements that came out of it I think are helpful.
And yesterday we presented at the Law Society on the issue of passing of estate and trustee accounts, basically fiduciary accounting issues, and it was a really great group of people who seemed to have a very keen interest in the topic area.
It was a practical sort of blow-by-blow, step-by-step approach to accounts that we took the first half of the seminar on to discuss, and we were all on the panel together with Avi Dahari, another excellent estate account preparer and presenter. What I wanted to just talk about in today's podcast was a couple of issues that came up after the questions that seemed to really focus on. One of them is this idea of what is this concept of an executor de sanctor.
There you go, throwing your Latin around.
That's right. My Latin is fully on. So, Susanna, what are we getting at there, and why is that an important element of an estate accounting issue?
Well, when we're looking at these kinds of obligations of fiduciaries to account, which we know is sort of the basic obligation of a fiduciary, an executor de sanctor is someone who, on their own volition, their own free will, basically assumes these kinds of responsibilities, acts as an executor, even though they may not technically be appointed an executor under a will or a trustee under a trust document, but they take these active steps to actually do things, to administer an estate or a trust, and in which case they, by virtue of taking on the job, assume these responsibilities that they might not otherwise have realized that they were signing up for.
And I think that's where the element is of surprise, is that all of a sudden you are classified as a fiduciary, therefore you are obligated to fiduciary account. And many people who get these roles don't understand that they think that maybe they're just assisting, or that they're an agent, or that they're helping out. But the fiduciary cloak gets thrown on you, and then you're stuck into the world of fiduciary accounting.
And you can see how this could be something that could easily arise, like when you think about a death, a situation, someone just sort of stepping up to the plate and really just trying to help the family to get their ducks in order. And so they go to the bank, they deal with individuals advising of the death, trying to get some information about the estate, and suddenly they become this concept of an executor dissontor.
And even in a scenario where you are actually named, the cutoff of the job is very important with estate accounting, and the idea that even if you're named in the will and you take some early steps, you may be surprised by the complexity of the estate or the lack of assets, and you may want to consider getting out of the job. And again, it's the number of steps you've taken and the type of steps you've taken that may have created the fiduciary obligations to account. All right, so we want to avoid those kinds of surprises, but we also want to be mindful of the fact that when we're in that role, we will have to account. And in Ontario, we have various components of the rules of civil procedure and the statutes that obligate accounts to be done by fiduciaries. One of the key elements of that statute kind of sphere for accounting that we talked about yesterday, and one that people were anxious to learn about and learn more about, was this whole idea of the prudent investor rule.
And that's a really interesting one, especially as we're seeing larger and larger estates these days with different varied types of assets, some of which are included in there as being these investment accounts or portfolios. And the question then becomes for an executor, well, how is it that you manage these, and how are you going to ultimately be judged in terms of that management?
And we're lucky under the Ontario Act, we have similar rules to the United States. In a sense, we have this prudent investor rule. In the Ontario Act, Section 27 really does codify the expectations of a fiduciary in an environment where the prudent investor rule is going to apply.
And there's a lot of guidance to be given by that section, as you say, in the subsequent sections in the Trustee Act, to help these individuals who are dealing with these kinds of assets know what it is that they're entitled to do, whether or not they're entitled to delegate, what kinds of investments they're allowed to invest in, and ultimately the standard by which they're going to be judged, as you say, in this prudent investor rule, is based on a prudent investor. And what would a prudent investor do in these, the given economic conditions, given the nature of the assets, given the nature of the beneficiaries, and ultimately what it is that they need to do with these assets in order to not be criticized, because I think that's the real major concern at the end of the day, not to be criticized and to hopefully also be compensated.
And not to be sued for losses and things like that. And we often will sit, the courts pursuant to these provisions really look at conduct of the trustee. It's not the ups and downs of the markets that they're testing, it's the conduct of the trustee. Has that trustee gone and got advice from an independent advisor setting out precisely the nature and extent of the assets portfolio and the diversification required and so on?
And that's really an important change that we've seen certainly from the previous legislation, where investors and trustees at that time had sort of a limited list of assets and investments in which they could actually invest estate assets. Now it's an expanded list. We're talking about things like mutual funds, and as you say, they're being judged not on each individual investment, whether it goes up or it goes down, but on the asset mix, in the entire portfolio, and ensuring that it's doing as well as it can in the circumstances.
Well, that's terrific. So thank you so much, Susanna, for joining us today, and thank you for watching or listening to Holland Estates and Succession Planning. We'll see you at our next podcast.
Thank you, Ian.
Thank you.
You have been listening to Holland Estate and Succession Planning by Ian Hull and Susanna Popovic-Montag. The podcast that you have been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.